Welcome, everyone. My name is Robin Gross, and I'm the policy chair of the SF Bay Area Internet Society chapter. And I want to thank you for joining this edition of our monthly tech policy webinars. We're going to be talking about the Google v. Oracle Supreme Court decision. We started doing these tech policy webinar series earlier this year, the first Monday afternoon of each month. And so this is the fourth one that we've done now, and we'd like to invite you to take a look at our ISOC YouTube channel page if you'd like to have a look at what some of the other issues that we've talked about in the past. Okay, well, let's get into this particular case that we're going to talk about today, the Google v. Oracle Supreme Court decision. Well, this case started back in 2010 by Oracle America Incorporated after it acquired Sun Microsystems. You may recall Sun was the company which originally built the Java language and the platform. Well, Oracle owns the copyright, of course, to the Java SE, which is a computer platform that uses the popular Java computer programming language. In 2005, Google acquired Android and sought to build a new software platform for mobile devices. Now, to allow the millions of programmers familiar with the Java programming language to work on its new Android platform, Google copied roughly 11,500 lines of computer code from the Java program. Now, these copied lines are part of a tool called Application Programming Interface, or APIs. And an API is a tool that allows programmers to call up pre-written computing tasks for use in their own programs. So it's worth pointing out that in this case, the damages sought were more than 8.8 billion, that's with a B, US dollars. So this was a very significant case with a lot on the line. And in terms of what the holding was here, well, the Supreme Court held that Google's copying of the Java API, which included only those lines of code that were needed to allow programmers to put their accrued talents to work in a new and transformative program, was a fair use of that material as a matter of law. So this case has been hailed by a number of people in the industry as a big win for fair use. Also a big win for software developers, because arguably they've got freedom to create interoperable systems. Although it remains to be seen just how broad or narrow of that ruling we can expect. The US Supreme Court concluded that Google's copying of the API to re-implement a user interface, taking only what was needed to allow users to put their accrued talents to work in a new and transformative program, constituted fair use as a matter of law. Now, in its fair use analysis, the court concluded that Google's limited copying of its API is a transformative use, because the copying led to the creation of a different computing environment and the creation of a new platform. So this is seen as a big win for software developers who want to build interoperable systems. And it is tempting to view the court's ruling as a clear win for software developers who want to re-implement portions of proprietary computer programs without a license, which is the industry practice. But the holding may prove narrower and more uncertain than it appears. Fair use analysis is involved in these cases, and they are flexible, and they are uncertain, and they are highly factually dependent, and they adapt to technological change. Time will tell whether or not this was a landmark precedent, to the extent to which, I should say, because it certainly is an important holding about certain software code can be fair use as a matter of law. Okay, so let's introduce our panelists for today. We've got Matthew Sarbaria. Now, Matthew is Oracle's attorney. He's a senior vice president in the legal department and the associate general counsel at Oracle and the manager of the patent, trademark, and copyright group. He's a former attorney at Ochoa and Monges and a former legislative assistant with the California State Assembly. Matthew got his JD at the UC Berkeley. Okay, our next panelist is Google's attorney, Michael Kwun. He is a partner with Kwun, Bhansali, Lazarus, and also on the board of directors of the East Bay Community Law Center. Michael was Google's first in-house litigator. He's also a former staff attorney for the Electronic Frontier Foundation and also got his JD at UC Berkeley. Our third panelist, legal expert, Professor Tyler Ochoa, a professor of law at Santa Clara University School of Law. He's the former academic director of the High Tech Law Institute and the former director of the Center of Intellectual Property Law at Whittier College. Professor Ochoa is also a former clerk of the Ninth Circuit Court of Appeals, a former attorney at Brown and Bay, and most interestingly, a two-time Jeopardy champion. And he got his JD at Stanford University. Okay, so let me just explain the format that we're going to use today. First of all, each panelist will provide introductory remarks, and then we'll have a brief moderated discussion among panelists, followed by questions from the attendees, followed by brief final remarks of each panelist, and finally a heads up as to what we are talking about on our next tech policy webinar. So we're asking the attendees to please use the Q&A feature in the Zoom platform to ask the questions of the panelists throughout the presentation and the discussion, and we'll collate those questions and we'll ask them of the panelists during the session. Okay, so without further ado, let's go on to our first panelist. We've got Matthew Sabaria from Oracle. Please, Matthew, go ahead.
Thanks, Robin. I'm not sure that I should go first, given the outcome of the case, but I will take this opportunity to do so. It will come as a surprise to no one here that I respectfully but strenuously disagree with the court's decision in the case. And I would also say that I don't think it's entirely accurate to characterize the view of the decision in the software industry as a consensus view that this outcome is good for the industry, is good for interoperability. I think that, as you said, it does remain to be seen what the ultimate impact will be. But there are many reasons here to conclude that the impact will be quite the opposite, particularly for smaller developers who lack the resources of the dominant platform companies like Google, even large companies like Oracle, who can weather these sorts of changes in the law. The net of this decision is that the decision weakens copyright protection for software, and in particular, weakens copyright protection for the user-facing parts of software, what the decision calls the declaring code for the API at issue here. Understanding that distinction between declaring code and implementing code, which is found nowhere in the copyright statute, is very important when we think about the long-term implications of the case in industry. The declaring code is the public-facing part of the code, the part of the code that a user, a programmer, an application developer interacts with in writing a program. The implementing code, by contrast, is typically hidden from the user by design. That is the code that does the hard work under the covers, so to speak. And a well-designed platform will be produced in a way that allows users to interact with the product, with the platform, use it without having to delve into that implementing code. So what the court has concluded here under the fair use analysis is that that user-facing part of a software product is not entitled to copyright protection, at least on the facts of this case. But the part that's hidden from public view in most instances, or at least not typically seen or interacted with by developers, well, that's okay, that's still protected, don't worry, that's all fine. And if you think about that distinction that the court creates here, that the court latches onto, that suggests that the parts of products, particularly commercial products, that give them their commercial value, that create appeal for the users of those products, that make those products appealing in the market and ultimately allow them to be successful commercially, that part of the product has less protection or no protection under the outcome in this case. And so any developer who's investing time and effort and money creating a new software platform program should be concerned that a third party, like a Google or anyone else for that matter, can come along later and copy the user-facing parts of their product, the parts of their product that they designed, that they created, that make it appealing to the public and that created their customer base, their user base. That part is, under many circumstances, if we follow the logic of this case, now can now be copied by others into what amounts to a commercial substitute in the market. That takes control away from software developers and gives more leverage to the companies like the Googles of the world that have the resources to copy the parts of another's product that made it popular and then re-implement the parts that are under the covers, the implementing code. That's the first point I would make. And one other point I'll make here at the beginning is that we should be very concerned, because this case is the only case, the first case and the only case that I'm aware of where the court has found, in effect, that a product is entitled to less copyright protection, that it loses copyright protection because it has become popular and widely used in the market. The majority in the case effectively draws that conclusion. They say, well, listen, Google copied these API declarations because they were well known and widely used by many, many, many developers around the world. That's why they copied them, so that they could tap in to that user base, make those Java developers, those Java users, Android users. That's a big concern. And I'll stop there for now.
Thank you very much, Matthew. Michael, would you like to be our next presenter, please?
Sure. I just wanted to touch on a few things that I thought were interesting about this case and this opinion. And the first one is the fact that the court sidesteps the first question presented entirely. They don't address whether or not these software interfaces are protected by copyright in the first instance at all, and instead say, assuming they're protected by copyright, Google's use was a fair use nonetheless. And I think the thing that's interesting about this, well, there's a number of things that are interesting about this, but a thing that is interesting about this is that that approach echoes the approach of Judge Boudin in his concurrence in the Lotus v. Borland case 26 years ago in 1995. And Lotus v. Borland, as many of you will know, was raised some similar issues. It was also about interfaces, but it was about the kind of end user interface. It was about the menus in Lotus 123, the spreadsheet program. And the issue was that Borland had a competing spreadsheet program that used that had an option to use the same menu structures as Lotus 123. And the question was whether that was copyright infringement. And the majority in the First Circuit held that those menu structures were a method of operation and therefore not protected by copyright law at all. And Judge Boudin said that in his view, the easy question was who should win this case? And he thought that clearly the answer was Borland. And for him, the interesting question was why should they win this case? And for him, he thought that the issue really was that the reason why Borland was copying these menu structures was because they wanted users to be able to leverage their own investment in the product. So a lot of users had created macros, and the macros in Lotus 1, 2, 3, the way you wrote them depended on the menu structure. So you had to copy that menu structure if you wanted people to be able to use their macros. So Judge Boudin said, well, that is a privileged use and that should not be protected by copyright. And in his view, the best way to explain that in legal doctrine was the fair use doctrine. And so if it were up to him, he would have ruled for Borland based on fair use. He did recognize, however, that ruling based on fair use would have created what he called a host of administrative difficulties, namely that fair use can be difficult to litigate and you could get different answers in different cases, and it would provide less certainty. So he felt that the majority's approach of method of operation was defensible and perhaps from an administrative standpoint made more sense. Nonetheless, he went with the fair use approach. And at the time that the First Circuit decided this case, the chief judge in the First Circuit was Justice Breyer, then Judge Breyer. And so he overlapped with Judge Boudin on the First Circuit for a couple of years, and 26 years later, he wrote our majority opinion, and it really does echo a lot of what Judge Boudin said. And so I thought that was kind of an interesting similarity, given the similarity in those two cases. So the second thing I wanted to focus on is, as a litigant, if you win a jury trial and the other side is appealing, you're going to focus on the standard of review, and you're going to try to find the aspect of the case that is as facty as you can make it. And you're going to want to say, well, the standard of review here is highly deferential, and therefore I should win. It doesn't matter if you would have decided it differently. The jury decided it for me, I win, end of story. So that actually, if you look at the briefs that Google filed, was a lot of what we said in the Supreme Court. And so we said fair use is a highly fact-specific question. The jury had, weeks of testimony from dozens of witnesses, and they decided for us, and that should not be lightly overturned. We lost completely on that issue, on the issue of the standard of review. We said that this is required to be reviewed deferentially, and Justice Breyer said, no, I don't think so. Actually, this is, there are some issues maybe that require some deference, but by and large, this should be decided de novo. So we can second guess what the jury did as much as we want. You don't always get exactly what you want, but sometimes you get what you need, which is indeed what happened here for us anyway. And the other issue I want to focus on here in these opening remarks is in fair use, we have 4 statutory fair use factors that must be considered. And if you asked anyone a few months ago, what are the most important factors? Everybody would raise their hand and they would have said factors 1 and 4, factors 1 and 4. And then if you said, okay, what's the third most important? Probably people would say like, well, actually, I never get past those first 2. But if somebody was forced to, they'd say, well, plainly it's factor 3. Factor 3 is the third most important of these factors. And then if you said, okay, well, what is that remaining factor? There's a lot of people who probably wouldn't even be able to tell you. Okay, they probably would be able to tell you what the second factor is. It's the nature of the copyrighted work, but nobody pays any attention to it. That's what they would tell you. And if you look at the way these decisions are written, it gets short shrift all the time. So this decision, Justice Breyer, writing for the court, opens with the second fair use factor. And he says he's opening with the second fair use factor for purposes of exposition. And frankly, he never really explains exactly what he means by that. But I thought it was a very interesting choice. And the reason why is because let's consider what fair use is. Fair use is saying, let's assume, or let's say that we've concluded that something is protected by copyright and it's taken. Is there an argument that nonetheless that conduct should be allowed under the law? And fair use says, if you find fair use, yes, that taking of copyrighted material should be allowed. And so the question is, the second fair use factor basically asks, is okay, this work is copyrighted, but just how copyrighted is it? Now, that's not a phrase you'll actually see in any cases, but really what it's saying is how close to the core of copyright is something. And if you have something that is a fanciful work, highly creative narrative that is being created by the author, you can imagine that that really strikes at the core of copyright law. And that's the sort of thing we seek to protect. And then meanwhile, there might be other things like you might be writing a history book, and history books should absolutely be protected by copyright. But history books are filled with facts, or at least one hopes they're filled with facts. And those facts are things that are a given. And those facts, you can choose what facts to present in your work. You can choose how to present them. There's all sorts of things that can be protected by copyright. But at its core, in a work of history, you are relying on material that is in the public domain. And so even if you have a copyright in your history book, your copyright is a lot closer to the line of unprotected. It's still protected, but it's a lot closer to that line. And so the fair use doctrine, if you think about it, is taking something that is on one side of that copyright line and saying, even though it's copyright protected, we're going to move this conduct over to the other side and say it's okay. And what the second factor is asking is, how far do I need to move that conduct? If that conduct is way over here, I've got to move really far to argue that it's a fair use. But if that material was just barely protected by copyright, well, maybe it's an easier lift across that line. And we see this all the time in copyright textbooks and copyright academic articles and in briefs. We talk about thin protection, that there's works that have thin protection. And if you have thin copyright protection, fair use should be easier to establish. And so maybe you don't need to do it in every case, but it actually, I think, makes a lot of sense that the first question you should often ask is, just how protected is this? And if it's not protected that much, well, then that frames the other factors, and you know how far you need to lift that conduct in order to make it a fair use. So there are a lot of commentators who have questioned the whole notion of starting with the second fair use factor. And I wouldn't have recommended that you put that in a brief that, oh, the most important factor is the second fair use factor. But I do hope that people pay attention to that and start asking some questions about that. So those are the 3 points I wanted to raise, but I do want to raise one other one based on Matthew's comments. I do want to just say that one of the other things that was interesting about Justice Breyer's opinion, the court's opinion, was that it really recognizes that copyright is not there to protect any person. It's not there to protect the defendant through fair use. It's not there to protect the plaintiff. And that's kind of strange because those are the parties in the case, the plaintiff and the defendant. That copyright really at its core, according to Justice Breyer, is there to protect everyone. It's there to protect the public, and it's there to make the world a better place. And the way you make the world a better place is by creating things and by not stifling the creation of things. And so you need to have this balance. And Justice Breyer's opinion stays resolutely focused on the benefit conferred on the public. And I think that's a welcome change from some some copyright academic works or even some opinions. And so I thought that was very nice as well.
Thank you very much, Michael. Now we'd like to hear from Professor Tyler Ochoa, please.
Thank you very much. Pleased to be here. Just riffing off of something that Michael said, before this case, you absolutely would have said that the second factor was the least important of the 4 factors. And yet it's ironic that out of the 4 major Supreme Court decisions concerning fair use, this is the second one in which the second factor has played a decisive role. The Harper and Row versus Nation Enterprises case from 1985, the court also placed a great deal of emphasis on the second factor in that case, on the fact that the text had previously been unpublished and was about to be published, was about to be publicly released when it was scooped by the alleged fair user. There, the Supreme Court held that that was not a fair use. What's my stake in this, right? You've got one lawyer from Oracle, one lawyer from Google. I'm supposed to be the guy in between. On my screen, I'm literally in between the 2 of these. I don't know about yours. I don't have any financial stake in this outcome. I am not a programmer. I am not a software developer. I don't work for a tech company. I don't own stock in any tech companies. I do own an Android phone, but I literally only use it for text, maps, and making phone calls. In that sense, I'm supposed to be the neutral observer here. And yet I should point out, I'm not neutral in terms of the outcome because as an academic who studies copyright, I did sign one of the amicus briefs that was filed in favor of Google. And I signed it on the first question, the copyrightability question, saying that I didn't think this code in this instance should be protected by copyright. The Supreme Court said, well, we're not going to decide that question. We're going to assume it's protected and we're going to decide the fair use question instead. And I didn't sign the brief on the fair use question, but I just, wanted to make it clear that that's where I stood. Why did I stand in that position, and why do I think that this is a good thing? Well, first of all, we can look at it the way that Justice Thomas looks at this, say, well, let's read the text. What did Congress intend here? And what Congress clearly intended was to leave questions like this to the courts, right? Congress studied this issue. They adopted the report in 1980 saying that software is copyrightable as a literary work. The definition of literary work is clearly broad enough to include software code. And yet Congress did not make any special carve-outs for software in Section 102B, which says, in no case does copyright protection extend to any idea, procedure, process, system, or method of operation. And Congress did not make any special provisions for software in fair use, right? Well, what do those 2 things have in common? Section 102B, idea expression, fair use, both of them are judicially created, policy-driven, case-by-case determinations, right? And they were created by the judiciary as exceptions to copyright case law. And then in 1976, Congress codified those 2 things. They recognized, yes, we think idea expression is a good thing. We think fair use is a good thing. But they're not pushing any particular outcome. We're codifying these, we're recognizing these as defenses, but we're saying that courts should continue to apply these defenses on a case-by-case basis, right? So Congress really intends this to be left to courts, and courts are therefore deciding this not based on statutory intent, because Congress isn't doing fine balancing, right? They're just saying in general, software is copyrightable, but it's subject to these exceptions, right? The exceptions are applied on a case-by-case basis based on policy. And the policy here can be looked at from an ex ante perspective or an ex post perspective. Ex ante, when you're setting out to create software in the first place, you want to make a good software human interface. So you've got it, you need to make sure that copyright is strong enough that you've got an incentive to invest enough time and money to create a good software human interface. And of course, when you're doing that, you don't want people to come along and then be able to copy all of that investment that you spent making a good software human interface. Versus ex post. And ex post, right, the question is it more efficient to have new people come along and develop their own new interface, something new that users have to learn? Or is it more efficient to have people have a common interface, a common language, a common way to operate these programs, and to compete on the implementation of that? And on that policy question, my opinion is that the Supreme Court got it exactly right? That it's much more efficient to have a standard language that once people have learned how to use this, it's more efficient to allow other people to use that sort of standard human interface and to compete on the implementations. Now, I think Matthew is absolutely correct, right? The part that gets less protection here is the human-facing part of this. The part that gets more protection is what was under the hood, right? And that seems counterintuitive for a bit, until you look at the economics of the situation. And so an analogy that comes to mind here is the PC wars in the 1980s. You had IBM PCs that had an open architecture that could easily be cloned, and you had lots and lots of programs developed for IBM PCs. And then you had the Apple Macintosh and Apple PCs that were closed architecture, and they sued anybody who was doing any type of cloning. And if you wanted to do anything with Apple, you had to go through Apple. And what you ended up with was that Apple had a very niche market. They never had more than 10 to 15% of the market in personal computers. IBM PCs and PC clones, other things based on the Microsoft operating system, you had a sort of a very robust open architecture, open environment, lots of development going on. So empirically, it seems to me it makes a lot more sense to have this type of open architecture. And I think what happened here, part of the problem was that Sun Microsystems intended for Java to be an open architecture and to compete on implementations. When Google copied, Sun wasn't necessarily happy about it, but Sun Microsystems didn't sue them. Sun Microsystems CEO testified at trial that he thought Google should be able to re-implement the API in this way. And it wasn't until Oracle bought Sun that it sort of changed it and said, no, we don't want other people to be able to use that in this way. You know, bait and switch is too strong a word here, but there's a certain flavor about that Sun wanted the benefits of having an open architecture, and then Oracle wanted to close it sort of after the barn door had been opened. So I do think the court got it right here. The real question is, how much of an impact is this going to have on fair use in the future? And frankly, it looks to me like it's very software specific. I think it'll affect our interpretation of the fourth factor, and we can talk more about that as we go along. But the economics of the situation are very specific to the software industry, to software programming. And I'll kind of be surprised if it has a super large effect on fair use outside of the software industry.
Thank you very much, Professor Ochoa. Now let's have some open questions for all of our panelists and some open discussion amongst our panelists. I'll kick things off with a question. Google could have licensed Java for less cost than the cost of the litigation. So how cost effective is it to litigate and win such cases? And how much cover can this precedent really provide to other third-party coders in other software development matters? How broadly or narrowly can this ruling be applied in other contexts? What do you think?
Well, I'll say that this litigation was not cheap, and but I do hope that the next time around, it'll be the next plaintiff, the next defendant won't have to spend quite so much on the issue because a lot of it has already been covered. I do think that if we had if Google had a clean win on the first question presented, it would be a lot easier for the next Google who wanted to make use of some APIs. And so I do think
sorry, Michael, you muted yourself here.
there we go. Sorry. I do think that the fair use issue does raise this whole point that Judge Boudin actually self-criticized with, saying that the administrative difficulties from the fair use doctrine can be kind of tricky. The one thing that I will say about this opinion in terms of clarity is that if you look at the language of the opinion, it's fairly broad. And Justice Breyer talks about fair use as a matter of law. And without a doubt, there's fact issues that are going on here. But I think that those fact issues will largely fall, at least in the same general direction in future cases. So I think that that maybe the justices who didn't want to address the first question, or were reluctant to rule for Google in the first question, perhaps, wanted to leave that question open. Their concern was, okay, well, this is a fair use, but what about the next person who copies the APIs, but does something really bad with them? And I frankly, I understand why they have that concern, because this is a big technological issue. They're not computer programmers. They're afraid of that possible concern. But Justice Boudin, in his concurrence, also had the same note. He said, you know, maybe actually the answer is that all the uses of these menu items are privileged. And, you know, which really then raises the question of why are we messing around with fair use here? And I think that the thing that is less understood by the non-technical justices is that the whole point of an API is to abstract away the very tool-like purposes here. And those are the core of why this is a fair use. And so I do think there's probably still some issues that are going to need to percolate through the courts, but hopefully the next time around it will be more cost effective to litigate. But I will say that I've had somewhere around half of my legal career, I've been working on this case. So it's certainly been an interesting ride for me.
Did any
Matthew, you're on mute.
I'm sorry, I just wanted to chime in briefly on the question of cost. I agree with Michael. If the court had answered the threshold question on copyrightability, we would be in a situation in which licensors and licensees or developers would have greater certainty. And as it stands now, we do face the prospect in industry of additional litigation around the contours of fair use in similar or analogous situations. Of course, I think that certainty would have been achieved and should have been achieved by addressing the first question head on and finding that the API declaring code was legally entitled to copyright protection rather than assuming it for purposes of argument. So I agree there. I'd also note here, you mentioned the cost of obtaining a license. That highlights another issue to think about from a software development perspective here. Google could have obtained a license here, a commercial license, which it tried to negotiate with Sun, but it also could have used the API declaring code under the open source license that Sun and Oracle have made it available under, and that would have, of course, been free of charge. But Google chose not to use the open source version because it did not want to comply with the applicable open source license requirement. In this case, the GPL's requirement that any changes, improvements, or modifications that they or their downstream users make would have to be contributed back to the open source community, would have to be publicized and made available under the same license. that was commercially unacceptable to Google. I point that out here because when we look at the net of this case, the outcome here, weaker protection for interfaces, it may have some fairly significant implications for open source development, which is a very important part of our industry. Open source licenses depend on copyright for their enforcement. And we have operated for a generation now in an environment where developers have a wide array of different open source licenses with different terms and conditions from which they can choose and find a suitable license for their particular development objective. Many developers may choose a very permissive open source license that effectively allows downstream users to do whatever they want with the code, including modify it and keep those modifications proprietary, incorporate the code into commercial products and the like. And others may go to the other end of the spectrum, as Sun did, where they wanted to, as Professor Ochoa mentioned, make Java open, that is, offer it to the developer community on an open source basis, but at the same time be able to maintain a commercial business and support the substantial investments in R&D by having a parallel commercial licensing business. So they carefully chose the license, the open source license that they did, the GPL, because they recognized that that would enable developers in academia, hobbyists, schools, and even some commercial users to avail themselves of the technology, to experiment with it, improve it, make changes to it, not be subject to any particular compatibility requirements, as long as they contributed those changes back to the community. And that large-scale commercial users who would want to protect their proprietary additions to the code would gravitate towards the commercial license and comply with the applicable compatibility requirements. Now, after this decision, we are operating in a world in which copyright protection is less certain in many circumstances for software. And that can have a detrimental effect on the viability of open source licensing models, particularly in larger scale commercial enterprises. So what you could see, and of course remains to be seen how this plays out in practice, but what you could see are scenarios where companies that are doing what Sun did and what Oracle continues to do to this day, investing very heavily in open source software development, like Java, like many other projects, MySQL and others, question the wisdom of the enforceability, of the viability of those types of models, and consider moving back to more proprietary models that give them remedies other than copyright to protect their R&D investments, remedies like contract remedies, or even trade secret remedies, which of course are not available in an open source environment. And then one last point, Professor Ochoa was referencing the public good here. I think Michael also referenced that. There's no disagreement here that is properly the focus of copyright. The problem that we face now, though, is where the incentives go for making and maintaining the very high levels of investment required in software, if it will be easier for third parties to copy the user-facing parts of a program that, as I said earlier, give it its commercial value and step into the market with a substitute. I don't think that it's the case that the balance there tilts on the side of let's lower copyright protection because that will incentivize the creation of new works. I think the effect may well be the opposite.
Well, I agree with both of you that there is uncertainty left here, right? If we'd had a ruling on the copyrightability issue, we have a much cleaner line. We know what we can and can't do. By relying instead on fair use, which relies very heavily on case-by-case balancing, we have an inherent amount of uncertainty left. But in my view, that may be a good thing because it leads to incentives for settlement, right? On the copyist side, if you're in Google's position, very, very few companies have the resources that Google could devote to litigating this question for a decade and spending millions of dollars to litigate. It's far cheaper in most instances to license, to go ahead and pay a license to get the rights to copy than it is to copy certain parts of the code and have to re-implement the other parts of the code on your own. And then if you're on the established company side, if you're on the Oracle Sun Microsystems side here, right, you can still get a piece of this action if you're willing to license. But you might end up with nothing, no piece of the action, if the parts of the code that you're trying to protect can be copied and can be re-implemented. So that gives the Oracles of the world an incentive to license on fewer conditions with less sticky terms that the defendant might not be willing to do. So it seems to me that it gives both sides an incentive to license here. What ends up happening is that the people who are willing to litigate are the larger companies that have the resources to litigate on both sides. And the smaller companies that can't afford to litigate are in a position where if they're up against a larger company, it's going to be hard for them to go all the way. But that's an existing imbalance that always happens, right? Established companies have more money, more resources, they've got a built-in advantage. So I don't think that changes anything in terms of the built-in advantage. And I do think there are incentives on both sides because of the uncertainty to license here.
Thank you all very much. I'd like to now ask about the issue which the Supreme Court sidestepped in its ruling, and that issue is the copyrightability of the API itself. The juries said no to the copyrightability of the API. The appellate judges have said yes. And SCOTUS, the Supreme Court, said it presumes copyrightability. So how do you panelists anticipate this unanswered question will be addressed in the future, whether it's through further litigation or just business practice and business models?
Well, before I let the other two answer, I just want to correct something. The jury did not decide copyrightability here, right? The judge, the district judge, and the parties agreed that copyrightability, whether this was subject to copyright protection, was a question of law for the courts to decide. The jury decided what was copied, and the jury was going to decide fair use. Because the jury found that these lines of code were copied and the first jury was a hung jury on fair use, is the reason why the court went ahead and decided the copyrightability question. The district court held it was not copyrightable. The Federal Circuit held that it was. So let me just look and say, well, what is it that would be or would not be copyrightable? First of all, Section 102B is very clear. Any procedure, process, system, or method of operation is not copyrightable. So what you're actually doing, what the program accomplishes, its task, its method, that is not copyrightable. A name by itself, a label, a one-word label or a two-word label, is not by itself copyrightable. Words and short phrases are not copyrightable. What is copyrightable is the selection and arrangement of names, right? You had some 6,000 methods at issue here. The names of all 6,000 of those arranged into 600 classes, arranged into 37 packages. It's that hierarchy, that taxonomy, what is sometimes referred to as structure, sequence, and organization, which doesn't always mean the same thing in all contexts, but in this case, right, it's the hierarchy of the names into packages, classes, and methods that is essentially protected by the declaring code. So with that clarification, I will let the two combatants go at it.
Well, I think the question is, how does this issue play out going forward? And I'm not sure that I have an answer beyond perhaps stating the somewhat obvious that there will likely be another case at some point down the line by someone where an accused infringer asserts that the copyrighted work at issue, if it is an API declaration, is not subject to copyright, and that issue is teed up again and makes its way through again, and possibly is addressed in a subsequent case, which would of course bring up all the issues that we've talked about here and that were addressed in the Supreme Court and the lower court opinions.
I think we'll have to wait and see, but I think that in the next case, the outcome will be exactly the same for exactly the same reasons. And the way I get there is I take a look at what the court has told us about fair use and APIs. And if you look at the second fair use factor, of course, the most important fair use factor. If you look at the second fair use factor, the nature of the copyrighted work, if you're talking about a future case where what was copied was the APIs and nothing else, you're going to have the same outcome. The APIs are going to have the same nature that they have here. They're there to be used. That's why you create APIs, is because programmers are going to use those APIs to interact with your program. So on the second factor, you're going to have exactly the same outcome as you do here. On the first factor, the purpose and character of the use. Well, if somebody is creating a competing program and their goal is to use these same APIs so that people can leverage their existing knowledge, that's going to be the same as what we had here. Now, if they're using it for some other purpose, I don't know what that other purpose is. That's what you use APIs for. So if they use them for some other purpose, maybe we'll have a different outcome. But as somebody with some technical knowledge here, I don't understand what that copyist would be doing with them other than what Google was doing. So I think you'll get the same result on the first fair use factor. On amount and substantiality, you're always going to have a situation where in computer code, you abstract away the interface. The interface is the only thing that you as the programmer need to know to interact with this program, and you don't need to know anything about the code under the hood. The code under the hood will be the majority of the code. That's just the way it works. That's the implementing code. If somebody's copying the implementing code, well, then we'll get a different outcome, possibly, depending on how they copied it, how much, etc. But if all they're doing is they're copying the interfaces, well, then we're going to have on amount and substantiality, we're going to have the same thing, which leaves us with the fourth fair use factor. And on the fourth fair use factor, I think the thing that Justice Breyer noted in his opinion that I found interesting on the fourth factor is he said, you know, when you look at these APIs, when they're first created, they may attract users, which is to say programmers. They may attract users because of their expressive qualities. If you make APIs that are really, really hard to use, like, you know, to calculate the square root, you have to call the subroutine name Bob. You know, that would be a really bad idea. It would be poorly expressive and it would not be adopted by users, by programmers. So your expressive choice to call square root, that's a good idea, by the way. Your choice for that, that's going to have some ability to make your product successful. But at some point, what Justice Breyer noted is he said, as time passes, it may be valuable for a different reason, namely because users, including programmers, are just used to it. So in other words, at some point, the reason why you're going to want to use this is not because it's beautiful, not because it's great, maybe it is, but it's because it's there. All of these other people, who by the way, are not the copyright owner, all of these other people have invested their own time and energy in learning these APIs. And so for them, you will use the same APIs. And so what Justice Breyer noted is that when you copy these things, both of these issues are at play. And copyright law, to the extent that you want to favor the copyright owner, The expressive qualities are important, but the functional quality of it's just there and we're used to it, that favors fair use. And I think that you're going to come out with the exact same conclusion on these 4 factors in a future case as you do here. So although we don't have a clear answer that tells us, by the way, the answer is always fair use, the answer is, by the way, the answer is always fair use.
Yeah, Michael might be right. This is now the precedent, and lower courts are bound to follow it. That is obvious. I agree. But on the 4th factor, this notion that because a work became popular initially, was widely adopted initially because of some creative attributes, and it would lose protection later because it was so widely adopted, is troubling, and of course raises concerns that extend beyond the software space. We could make the same kind of argument for creative works in any number of areas, as the dissent pointed out, and several amici from outside of the software industry did in this case, and that raises concerns more broadly beyond software. I'd also note on the 1st factor, the court here distorts beyond all recognition its application of the transformativeness consideration in that factor 1 analysis. Of course, the court acknowledges that Google's use of Java in Android was entirely commercial in nature. So with that in mind, it needed to find some transformation for Google to prevail on that factor. And if you look at the facts of the case, again, looking at this going forward and what it means for the industry, Google here copied this code verbatim and used it for exactly the same purpose within Android as it's used in Java. Every one of those 6,000 methods does exactly the same thing in Android as in Java. Nonetheless, the court found that Android's use was a transformative use because it used the copied material in a computing device of a different form factor. It used it in a smartphone, a smaller computer that runs on a battery and has additional technology added to it, technology that you would expect in a smartphone, a touch screen, a camera, a telephone, all of the things that we're familiar with today. That also has implications for not only the software industry, because it suggests that if you are a program developer and you have created a program that runs in one computing environment, for example, runs on-premise on a server or a standalone computer, and another party comes along and copies the user-facing elements of your program and adds some additional features and puts your program in on a different computing platform, for example, makes it available on demand in the cloud. That scenario, which I don't think before this case anyone would suggest is a transformation under the court's misapplication of that concept here. So that, again, opens up developers to more copying, to more substitute uses without licensing or without permission. And I just add one last point is I'm not sure that the outcome would be the same in every case, because here the court's conclusion was, incorrect conclusion in my view, was that Android was not a clone or a substitute, a direct substitute for Java, and therefore was transformative. So that maybe kicks it over the line. But in some future case where Google or someone else comes along, copies the APIs, and creates a product that is more more exactly aligned, that is a clone of the original product, maybe you get a different result.
So I just wanted to push back on one notion there. Actually, I want to push back on many of them, but I'll only push back on one. And I wanted to push back on this notion of the same purpose. And I actually agree with what Matthew said in a sense. There is a sense in which what Google's purpose was using these APIs was the same, because that's what you do with APIs. So I'm not saying that it was crazy for Matthew to say what he said. It was not crazy at all. But I do think that there's a very real sense in which Google's purpose was very different. And the reason for that is that when you call the math.max method in Java SE, it takes you to code that calculates the maximum of 2 numbers. And when you do that in Android, it takes you to code that calculates the maximum of 2 numbers. But in the SE version, it takes you to the SE code that does that. And in the Google version, it takes you to the Google version that does that. And this is kind of a metaphysical point almost, but let me explain it with cheeseburgers. And what I mean by that is that if I go to a restaurant and I go to In-N-Out Burger and I order a cheeseburger, I'm going to get a burger that has cheese on it. If I go to my neighborhood restaurant in Noe Valley and I order a cheeseburger, I'm going to get a burger that has cheese on it. It's going to be a very different burger. I'm going to like one of those burgers better than I like the other burger. And yes, I like cheeseburgers, but I care a lot about which cheeseburger I actually get. And similarly, people care very much about how fast the code runs, whether the code runs requiring a large amount of power, whether it operates well under various other conditions. There are a lot of reasons why that implementing code matters a whole lot. And the whole notion that you are getting the same output, I think a lot of people would dispute, and a lot of programmers would dispute, that just because the answer that comes back says, by the way, 6 is bigger than the number 4, that answer is the same, does not mean you are actually consuming the same product.
Thank you all. I'd now like to turn to some of the questions that our panel attendees have submitted for the panelists' consideration. Our first question is from Jonathan Band, who asks, isn't the human-facing versus under-the-hood distinction a bit misleading in this context? We aren't talking about GUIs used by end users to use an app, i.e., we aren't talking about the car's steering wheel. Rather, the declaring code is something that programmers use to write programs.
So I agree that one can draw a distinction between user-facing code on one hand and programmer-facing code on the other hand. When we look at the world of software interfaces, we've got software to computer interfaces, we've got software to software interfaces, and we've got software to human interfaces. And in the world of software to human interfaces, you can have user-facing interfaces, as you talk about. You can have programmer-facing interfaces. And this case does involve programmer interfacing interfaces. So in that sense, it's different from a user-facing interface. When we're talking software to computer interfaces or software to software interfaces, everyone agrees that in order to make those interoperable, they have to be able to talk to each other. They have to be using the same formats. When we're dealing with software to human interfaces, this is why this case is harder than some of the precedent cases from the 1990s, is because there are different ways to talk to humans. Some of them may be better than others. Some of them may be more creative than others. And so that, I think, is the reason why some of the justices were reluctant to say that the software interface of the API was simply not copyrightable in the first place. I think it's a bit disingenuous to claim that they're not deciding that issue, because the remarks that they make in the second factor are really saying it's not entitled to strong software protection. It's thin protection at best if it's copyrightable at all. So in a sense, Justice Thomas is correct, right? Logically, it makes much more sense to say, is this copyrightable, and then make your fair use determination. And I think essentially the majority is saying, maybe it's copyrightable, but it's not very copyrightable, and it will only rarely be copyrightable. Should we draw a distinction between user-facing interfaces and programmer-facing interfaces? If we're going to draw a distinction, I'm not sure we should, but if we're going to draw a distinction, you're going to get more protection for user-facing interfaces. You're going to get less protection for programmer-facing interfaces. So in that sense, Google versus Oracle may not spell the end of protection for all user-facing interfaces, but you know, a lot of the rationale will be similar. But I think this was a better case for less protection because it was a programmer-facing interface than it would have been if it was a GUI or something like that. But Lotus versus Borland was a user-facing interface and had the same issues and came out the same way 25 years ago.
I think the interesting thing about Lotus v. Borland is that it was a user-facing interface, in that it was literally the menus that human beings go and click on to choose to print something or to do whatever. But the issue that got a lot of traction with the judges, and certainly especially with Judge Boudin, who I keep harping on him, but he wrote the concurrence, so his opinion didn't actually matter at all. But the interesting thing about it was this whole issue of the macros, and the macros, which used the menu structure, rendered the Lotus menu structure both a user-facing user interface and a programmer-facing user interface. So it's a kind of a hybrid case. But I think that the point nonetheless is, if you're going to make a fair use argument about about interfaces, that the programmer-facing interfaces have a stronger argument for fair use, and that's what I think that I heard you saying. And the reason they have a stronger argument for fair use is because you can't change them and still have those programmers who use them interact with you. If we take the cheeseburger interface that I was talking about, if my neighborhood restaurant is required to have people order a burger with cheese, we'll all know what's going on, the human beings. But, and a matter of fact, if I come in and say cheeseburger, you would understand that, even though I said the wrong thing. The computer won't understand you. Maybe in the future they will, and this will be a little different. But right now, the computer won't understand you. If you want to be able to make use of that interface, you have to have exactly the same interface. And that necessity issue improves the fair use argument for the programmer-facing interfaces.
Thank you both. Let's turn to our next question from the attendees. It's from S. Turner, who asks, practically speaking, what are the implications of the decision as regards firm-to-firm competition?
I think this is a tricky one to know the answer to, and I think it probably depends a little bit about which firms you're talking about. But if you're talking about two well-resourced companies who are facing a similar issue to the one that that Google and Oracle faced, I think it's harder to know exactly what they're going to do. It's going to depend on how mission critical the dispute is, and how much the dispute will answer the question of who is going to prevail in the marketplace, and that's going to trigger a decision of whether or not to go the distance on this litigation. But for smaller companies, I think that you're going to see this whole issue of there is still some uncertainty here, and as Professor Ochoa suggested, a lot of companies will say, well, maybe I'm right, whether they're the plaintiff or the defendant, maybe I'm right, but just to be safe, I'm going to settle this case. And so at least until someone else decides to push the issue, maybe we'll see more of those outcomes.
Yeah, I generally agree with that. I think the bigger risk is for smaller companies that don't have the resource, that will be pressured to accept whatever terms the larger platform companies require. We're already seeing a variant of this play out in the market, particularly in the cloud computing context, where smaller software companies and startups where their business model depends on making their product or their service available on a much larger company's cloud platform, like an Amazon or a Google or any number of others. This issue has been covered. It's been the subject of some of the antitrust inquiries that are going on now. There was an excellent article in the New York Times that discussed this issue. I believe it was in December of 2019, called Prime Leverage, discussing the leverage that Amazon's AWS platform has over smaller companies, where those companies make their product available, and once the product gains following, gains some traction in the market, Amazon will come in and offer the same or similar functionality on its own, undercutting the market for the original. Now, in most of those cases that have been covered, the original, the smaller company's product code was made available under a permissive open source license. So they took on the risk, and Amazon was free to copy it. At least that's my understanding of the facts. And so those smaller companies, in some instances, had to change their licensing model, move away from the permissive open source licensing to more restrictive proprietary licenses to try to prevent the platform company from copying their code and creating a substitute. Again, now with the developer-facing or user-facing code not subject to copyright protection under the Supreme Court's rubric, the platform companies have an additional, important and potentially powerful additional tool to engage in more copying of smaller companies' product code, even when that code is not made available under a permissive open source license.
So I agree with Matthew. Those are, I agree with your assessment of how things might play out, and those are some serious risks. The thing that strikes me is twofold. One, this is not a new problem, right? I mean, if we go back to the 1980s with Microsoft, right? Microsoft's operating system supported a lot of different application programs, and whenever one of them was successful, they just incorporate that functionality into the operating system and destroy the market for the app. So this has been going on for a long time. The solution then was antitrust litigation against Microsoft. And the solution now is, this is really an antitrust problem, right? This is really a problem of market standardization and platforms having too much power because of the benefits of standardization, rather than because they're sort of inherently technologically better. And so it strikes me that we should deal with it on an antitrust issue rather than trying to change copyright law to sort of give the small guy a boost here. I don't think that that's going to work in the end.
Well, respectfully, I don't think we'd be changing copyright law. We'd be maintaining copyright law. Here, we found fair use in circumstances not previously found and set a new precedent. So as I said, I think we're really giving the copier, the fast follower, if you will, a new tool, or at least a more powerful tool, to engage in that kind of activity of copying key features of competitor products.
We can debate on what was the status quo, but Lotus versus Borland's been on the book since 1995, right? Until the Federal Circuit's decision in 2012, that was the status quo, right? And there's been a lot of uncertainty between 2012 and now. And because the Supreme Court didn't directly address it, there will still be some uncertainty going forward. But I think we're better off than we were before the Supreme Court's decision.
Speaking of Lotus v. Borland, I do want to offer some cautionary notes for the next litigants, which is Lotus v. Borland was argued during a snowstorm in DC. Justice Souter arrived to argument late because he couldn't get his car to the courthouse. The courtroom was almost empty because the the observers couldn't make it to the courthouse. 6 days after it was argued in the middle of a snowstorm in DC, it was decided by an evenly divided court because, of course, they split 4-4. Everybody thought this was a hot issue, and we didn't get another case for 25 years. We had another case, it went up to the Supreme Court, and we had the middle of a global pandemic shut down our argument. We were supposed to have argument on March 24th of last year. And 10 days, it was like about 10 days before argument that we found out that we weren't going to have oral argument. I was sitting there wondering like whether or not I would be able to get on a plane or whether I would get sick from worrying about whether or not I'd get to go to DC and I'd miss the most important argument of my life. So if we have another case come up and it goes to the Supreme Court, I hope everyone does a lot better than we've done in these last 2 attempts.
Thank you all. Our final question from the attendees is from Ken Kreckmer, who suggests a way to balance this copyright decision would be to transfer across the now public API an own trademark, e.g. Amazon. So receipt of Amazon by each end application would assert Amazon's control of the following communications across the API. Would the speakers care to comment on this balance mechanism that Ken proposes?
So I read this question in the Q&A and I was having a little trouble following it. Now that I've reread it, I think what he's suggesting is, can we use trademark in some way to retain control over something where copyright isn't allowing us to retain control? And I apologize if I've misunderstood that. If I have, maybe Mr. Kretschmer can clarify. In part, that was an issue in this case. If Google was licensing to use the Java API, and the Supreme Court expressly mentioned that part of those negotiations was the ability to advertise Java compatible. And instead, when Google re-implemented, they developed their own new platform. They're calling it Android. They're not calling it Java. They're not calling it Java compatible, right? It's written in the Java language, but they're calling it Android. So it is branded differently. And if you value the original implementation, the original brand, you'd rather go with Java, the trademark with which you are familiar. If you prefer the re-implementation, you'd rather go with Android. If somebody else wants to do this now, right, they would have to come up with a new trademark under which to do it. And so, you're competing among implementations of the interface rather than saying, well, everyone's got to develop their own interface. And, well, maybe, right, if everyone develops their own interface, maybe the interface that's best is going to win out in the marketplace. But what the Supreme Court feared was the interface that's going to win out in the marketplace is going to win out not because it's best, but because it was first and most familiar. The QWERTY keyboard remains the standard, even though it is demonstrably less efficient than later developed keyboards. It's the one that remains entrenched. And so I think that's what the Supreme Court was concerned about. But yeah, I think trademark branding plays a role here, but the real issue is, what are we competing on? Are we competing on interfaces or are we competing on implementations?
So I took the question, I also wasn't quite sure what the question was, but I took a slight variant of that, which was maybe what you should do is you should insert your trademark into the API itself. And then when somebody copies the API, you say, ha, you copied my trademark, that's trademark infringement. And I'll offer 2 stories on that. One is that indeed the Java APIs have the word Java in them. But the thing from a trademark law perspective is that when the Google Android APIs also say java.lang.math.max, they are not using the word Java in there as a designation of source. And so trademark doesn't prohibit use of trademark terms. It prohibits their use in certain ways. And indeed, Oracle and Google, we had a lot of disputes. They've gone on for a long time, but Oracle never said that that was a trademark infringement. They said it was a copyright infringement. They also raised patent claims, but they didn't raise trademark claims. And the other place that I'll mention this as at least vaguely similar is Sega v. Accolade. And it's got a lot of stuff in the case, Ninth Circuit case, similar issues. But one of the issues that came up is that Sega controlled their own gaming platform. And if you put a cartridge into the Sega Genesis system, it had to have a special key in it. Otherwise, the program wouldn't run. And Accolade didn't want a license from Sega, didn't want to pay for a license. And so they figured out that there was 22 bytes, 22 characters that they had to copy. And if they copied those 22 characters, that was the key and they could get in. And as it so happened, the Sega system, when it found that 22 character key, it pops up on the screen, something that says that the cartridge is authorized by Sega. So that struck me as an endorsement, but it was an endorsement that Sega made. And it was an endorsement that Sega made and that Accolade, by putting in these 22 bytes, they triggered this endorsement. Nobody, as far as I know, said that was trademark infringement. And had that issue been litigated, I would hope that the answer would have been, that is beyond the control of Accolade. And the fact that they have to do this to get at the unprotected content, which is what the Ninth Circuit said it was in Sega v. Accolade, the fact that they had to copy this means that that's lawful. So I don't know if that's what Ken was asking, but that's my take on it.
Thank you very much. Now we've got time for just a few final remarks, brief final remarks from each of our panelists. And if we could start with Matthew, please.
Sure. Well, I think we've covered most of it here. I do think that this case does not bode well for creativity, for incentives to innovate, and it is a win for the fast followers and the copiers. It gives them an additional tool, as I mentioned before, to copy commercially important parts of software programs and offer those in the market in competition with the original, which is what happened, of course, here in this case. I agree with some of the comments of my fellow panelists. Professor Ochoa referred to Lotus and suggested that really the playing field here hasn't changed. I would respectfully submit that drawing an analogy between Lotus and the user commands at issue there, file, print, save, those UI elements that were used by users to create macros, which they wanted to be compatible with the Borland spreadsheet program, is so far afield of both the type of material that was copied here and the quantity of material that was copied here as to be largely unhelpful in our analysis going forward. So I will be interested to see how this plays out. It is interesting, I will note, that the decision in this case has already been cited in at least one copyright case outside of the software industry, a case involving the Andy Warhol Foundation and a piece of art that Mr. Warhol created based on a photograph of Prince taken in the 1980s. I think that case is in the Second Circuit. Professor Ochoa will undoubtedly correct me, I hope, if I got that wrong. The court found for the plaintiff in that case, the defendant is seeking reconsideration of that decision based on the finding in this case, and I believe particularly focused on the new and very different application of the transformation consideration under Factor 1. We'll see how that plays out. but it suggests again that the implications here are significant and really important to all industries, artists, creators who depend on copyright.
Thank you, Matthew. Michael, do you have any final remarks for us?
Sure. I just want to say that we have a long history in this world of appreciating the best product that comes around and appreciating it whether or not it was the first product that came around. You know, we've heard a lot about Lotus v. Borland, and Lotus came out with a revolutionary product, a spreadsheet. Borland came out with a pretty good spreadsheet, or so I hear. I actually never used it. But nobody uses Lotus 123 or Borland spreadsheet anymore. People use Excel. People think, and I think Excel is an amazing product. It's very, it has a lot of things that you can do with it that I think are great. I suspect it can do a lot more than Lotus 123 could do. It was the better product, not because it was first, but because it's actually the better product. Linux has taken over the computing world. It powers most of the internet. Linux is a reproduction of a lot of the internal interfaces that came from Unix. Linux was not the first, but Linux is the one that won in the marketplace. The iPhone, a lot of people have iPhones. My wife has an iPhone. I have an Android phone. The iPhone is an amazingly popular product. It is really quite an amazing product. Nonetheless, it was not the first product in this area. When I was in law school and shortly after I came out of law school, the Palm Trio was the hot device that was both a phone and a personal organizer. The iPhone was the better product. The iPhone was very innovative. It was not the first, but it's an amazing product and it's one in the marketplace. The last example I'll offer you is that I recently saw someone post a picture of a Yellow Pages that had arrived on every doorstep in their neighborhood. And they were quite shocked by this. And they posted this picture, and I noticed that the picture said, it had the tagline, the trademark, the original search engine. Well, the original search engine may have been, at least according to them, the Yellow Pages. And it had its time and it was innovative, but it is not the winning search engine. I'll let you decide what is the winning search engine, but the winning search engine is the one that people feel offers the most benefits and the one that helped them the most. So we should praise first comers who come up with ideas, but they do not own the product marketplace just because they were there first.
Thank you, Michael. Tyler, do you have any final remarks on this subject for us?
So I think we've covered the ground pretty well, and I think the three of us understand each other very well. Let me agree with Matthew that the notion that this is a transformative use, it's transformative in the sense that it helped Google create something new. It's not transformative in the sense that the code served very much of a similar function in the new program. I agree that that notion should not be extended. We disagree as to whether or not it was proper for software. I think it was proper for software because of the functionality. Software copyright has always been a poor fit, fitting a square peg into a round hole. That decision was made a number of years ago. But because of that decision, copyright is never going to fit software as comfortably as it fits other types of creative things, and it's going to create hard problems for it. So I do think we should be wary of extending precedents from software into other types of works, because I think the economics of those industries are very different. And I think the functionality of software makes results in the software industry very different than in other types of places. It's a Supreme Court opinion on fair use. Of course, it's going to get cited in other cases. But is it going to change sort of the backlash against transformative use that's been occurring in non-software cases that we've seen recently in the Second and Ninth Circuits? I'm skeptical that it's going to do that. I would be I'm going to be surprised if it has that effect.
Thank you very much, Professor Ochoa. You have the last word on this subject. Let's see if I can now turn our attention to our next tech policy webinar, which will be in August. That will be August 16th, Monday at 1:00 p.m. So it's going to be 2 hours earlier, that's Pacific time. We've got a session with the speaker from the ACLU, Nicole A. Ozer, and she is the Technology and Civil Liberties Director of the American Civil Liberties Union. So this is really an exciting opportunity for our members and attendees to get an opportunity to ask the ACLU about the work that it's doing in the technology and civil liberties space. And so I hope you all will register for that event. You can see on the screen there the URL for going to register for that. And with that, I'd like to wrap this up and thank you all for attending, and especially thank you to our speakers for this really incredible, insightful discussion on this very important new Supreme Court decision. And if you liked our discussion, I hope you will consider joining our chapter, the SF Bay Area Internet Society at sfbayisoc.org. And with that, I will bring this webinar to a conclusion. Thank you all very much for attending.